sure.
I welcome all of you on behalf of Pusa Road CP Study Circle of the Northern India Regional Council of our Institute ICI. Today we have a webinar with structured CP hour on Prevention of Money Laundering Act, and we have our learned speaker, star speaker, Dr. SHAMSUDDIN ji with us. We have also our former president of ICI, K.M. Agrawal ji is also with us, and other office we are Satish ji, Jagdeep ji, Rajiv ji, Dhamija ji, and Hemant Pava ji also. And it is my duty to introduce the Dr. SHAMSUDDIN ji, today's speaker. This Dr. SHAMSUDDIN ji, the founder, member and managing partner of SAM Legals LLP, is having an illustrious career of over 34 years in the field of legal profession, right from his scholarly days at the Legal Muslim University. After receiving accolades in LLB honors, LLM and PhD law from Aligarh Muslim University, Dr. SHAMSUDDIN first served MD University as lecturer in law and thereafter proceeded to Nigeria on a foreign assignment as senior lecturer in law at Faculty of Law, AB University, Zaria. In 1991, on his return to India, Dr. SHAMSUDDIN was promoted as an associate professor of law at MD University, which he served till his joining in the Enforcement Directorate. Dr. SHAMSUDDIN joined the Enforcement Directorate as legal advisor, served it for more than 2 decades, and reached the status of the Director Prosecution and Head of Legal Division. Dr. SHAMSUDDIN was the core member of the drafting committee that drafted the Prevention of Money Laundering Bill 1998 and the Revised Bill 1999, which led to enactment of the Prevention of Money Laundering Act 2002. Dr. SHAMSUDDIN represented India at international forum, including the Financial Action Task Force, with its headquarters in Paris, and Asia Pacific Group, having its head office in Australia. Dr. SHAMSUDDIN has been presiding officer of Debt Recovery Tribunal, Aurangabad, from 2009 to 2013, with additional charge of DRT Pune, DRT Nagpur, and DRT Mumbai. Dr. SHAMSUDDin represented the Directorate as Special Public Prosecutor and Special Counsel in complex legal cases during his tenure in the Directorate, and even thereafter. He now handles such cases before the Adjudicating Authority, Appellate Tribunals, High Courts, and the Supreme Court as Counsel for the Defense. He authored also so many books and attended the conference, seminars, training. The list is very long. I am escaping this, and he got some awards like Best Scholar Award of Aligarh Muslim University, entered Limca Book of Record 2001 edition, page 84, for achieving rare distinction in the legal field. This is the brief profile of today's speaker, Dr. SHAMSUDDIN ji. With request, I once again welcome SHAMSUDDIN ji, and over to you. I also welcome the other learned advocate, Amit Khemka is also with us. Dr. SHAMSUDDIN ji, sir, please, over to you, sir.
Yeah, good evening, friends.
Good evening, sir.
Good evening, sir.
Well, the topic assigned to me for this evening is the recent trends. Just put it in order. Yeah. Money laundering, recent trends, investigation, attachment, and prosecution. That is the topic.
Yes, sir.
Well, this is the area, which need to, which we need to focus on issues which are related to money laundering. But first of all, at the outset, I will discuss with its origin, how this law came into being. If we trace the origin of PMLA, then we trace its origin in UN Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substance 1988, to which India is a party. And that calls for prevention of money laundering and prevention of drug crimes and other connected activities, and confiscation thereon. Then the second is the Basel Statement of Principles, that is Switzerland, which was enunciated in 1989, which outlined the basic policies and procedure and banks should follow to assist the law enforcement agencies in tackling the problem of money laundering. Well, thereafter comes the FATF. FATF is a Financial Action Task Force, which was established in Paris in 1989, and it came out with 40 recommendations to combat money laundering. And the recommendations have been classified as AML CFT. AML recommendations are those recommendations which relate to anti-money laundering, and CFT is combating financing of terrorism. 40 recommendations relate to AML, and 9 recommendations relate to CFT, that those relate to financing of combating financing of terrorism. In total, FATF came out with 49 recommendations, and thereafter a political declaration was adopted by the UN General Assembly via its resolution number 17/2 on 23rd of Feb 1990, which calls upon the member state to develop a mechanism to prevent financial institutions from being used for laundering of drug-related and enactment of legislation to prevent such laundering. Thereafter, well, this is the international background, how this law came into being. So there was political declaration, and that political declaration was adopted by India. India is a party to that declaration. We ratified that declaration also. And in view of that, our bill, the first bill was introduced in 1998 in Lok Sabha on 4th August 1998, which is termed as Prevention of Money Laundering Bill 1998. In order to comply with the FATF recommendations, in order to comply with UN resolutions and political declaration adopted by the UN General Assembly, we came out, in fact, the government of India constituted a committee which was a high-powered committee to draft this legislation, and I happened to be one of the members of the drafting committee, which drafted the bill in the first instance on 4th August 1998, which was introduced in the Lok Sabha. And in the Lok Sabha, it was not passed on that day, but it was referred to the Standing Committee on Finance. And the government accepted the recommendations of the Standing Committee and thereafter introduced the revised bill, which is the Prevention of Money Laundering Bill 1999. This Prevention of Money Laundering Bill 1999 was referred to the Select Committee. And this Select Committee made its recommendations. I also happened to be, I happened to face this Select Committee also. And the recommendations of the Select Committee were incorporated in the revised bill, which is the second bill, that is the Prevention of Money Laundering Bill 1999. And this is the revised bill of 1999, which was passed by both the houses of the parliament and brought on the statute book as the Prevention of Money Laundering Act 2002. Friends, let me just point out here that though the bill became an act in 2002, and in short, hereinafter I will call it PMLA. So PMLA, that is Prevention of Money Laundering Act 2002, received the assent of the President of India on 17 January 2003, and that is why it is termed as Act number 15 of 2003, because the assent was given by the then President of India on 17 Jan 2003. And thereafter, we were engaged in drafting its rules and regulations, because no law can be given effect unless the rules and regulations take place. So that rules and regulation took some time, and from 2003 to 2005, we were really engaged in drafting the rules and regulations. And I happen to be one of the members with my directors, different directors, who drafted the rules and regulations to give effect to the provisions of this act, that is PMLA. And thereafter, the central government notified the date of commencement, and the date of commencement of this act is 1st July 2005. Now, I would request the audience, you can just interrupt and let me know if I am too fast, because there should not be any gap between you and me. There should be no communication gap between you and me, and that is the purpose of this webinar, that there should be no gap. So if I have to reduce my speed, then of course I can do that. Now, with this background, how this law was enacted, how this law came into effect. I have given the international background and the national background also, and how this law came into force with effect from 1st July 2005. We will now briefly discuss what is the purpose of this law, what is the aim and object of this law, why this law was enacted. This law, as we have discussed, that in order to cater to the national, domestic, and international needs of the member states, this law was enacted. And that is why this law is not restricted to regional boundaries of our country, but this law is a law which is of global application, because it is having its far-reaching implications. So let us understand the aim and object of this law. And aim and object can be better understood when we know what is the preamble of the act. The preamble of the act is, the preamble of PMLA is that this is an act to prevent money laundering. That is the first and the foremost. And second is that this is to provide for confiscation of property derived from or involved in money laundering. So the object of this act is twofold. One, to prevent money laundering. How can we prevent money laundering? We can prevent money laundering when the offender goes to jail, when the offender is punished. So that is the prosecution. How can he be punished? Once we file the prosecution complaint for the offense of money laundering, then the offender who has committed an offense, he will be tried in accordance with the provisions of the act. And thereafter, if he is found guilty, then he is punished and he is sent to jail. So that is the purpose of this law, that when we send him to jail and the offender is punished, then it will enable us to prevent money laundering, which is the first and the foremost object of this act. And the second is that whatever property he has derived or obtained directly or indirectly, the property which is involved in money laundering, that has to be confiscated. That he should not be allowed to continue to enjoy the fruits of that property. The money launderer who has derived this property, whether directly or indirectly, as a result of criminal activity relating to a schedule offense, then he has to be deprived. And how can we deprive him? We can deprive him when the property itself, which he has derived from such proceed, is confiscated. And on confiscation, the property is vested in the central government as if it is free from all encumbrances. So friends, the purpose of this law is twofold. One, the prosecution, and second, the confiscation. But before confiscation, there are two preceding stages which we will discuss later on, and those stages are confirmation and attachment. First is attachment, then confirmation, then confiscation. So that we will discuss when I discuss section 8, and in my presentation you will see. I hope you have got the copy of my presentation with you. Hello? Hello? I think.
Yes, sir.
I hope everybody has got the copy of the presentation.
Rajesh sir, can you please reply that?
Yeah.
Yes, sir. Phone पे बात करें हैं.
All right. Anyway, so friends, I hope you are following. Till now I have given the background how the law was enacted, the UN resolution, the UN. Thereafter political declaration, and then the law. The national efforts which were made to make this law as the Prevention of Money Laundering Act. And I also explained you the purpose of the act, which is twofold. Now we will analyze what is money laundering. What is money laundering? Here we will first discuss what is the literal meaning of money laundering. Literal meaning of money laundering is, in fact, money laundering means washing of dirty money. I mean, like when our clothes are dirty, we give the clothes to to a laundry shop, and the dust is removed, and then and thereafter, I mean, the dust is removed from the clothes. So then similarly, I mean, if we define money laundering in literal sense, it means washing of money which is tainted and to make it as untainted. That is literal meaning of money laundering. Now we'll see how money laundering is defined under PMLA. Here we have to first see the definition clause, which is section 21P. It is section 21P which defines money laundering. Money laundering has the same meaning as assigned to it in section 3, which means section 21P, which defines money laundering, leads us nowhere. Money laundering has been defined under section 21P, which means that it has the same meaning as assigned to it in section 3. Now we have no option but to refer to section 3. So what is section 3? Section 3 defines money laundering, and I quote, whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, shall be guilty of offense of money laundering. So under section 3, there are key words. When, if we elaborate it further, we find that the entire section, it is one sentence, and that entire sentence can be divided into two parts. There is one conjunctive there, and that is and. So the definition of money laundering can be divided into, yeah. Yeah, have you got PPT?
Yes, sir. Got it, sir.
Rajeshji, have you got, everybody
Yes.
got
Yes,
PPT?
sir. Yes, sir. Yes, sir.
Yes, sir, we got it.
Yeah. 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 See, the definition of section 3, it is, I mean, you can see on the screen that it is, I mean, the entire, definition can be divided into two parts. There is one conjunctive which is and. So first part is whosoever directly or indirectly attempts to indulge. Then there are disjunctives: attempts to indulge, or knowingly assists, or knowingly is a party, or is actually involved in any process or activity connected with proceeds of crime, including its concealment, possession, acquisition, or use. Then thereafter it and projecting or claiming it as untainted property shall be guilty of offense of money laundering. So friends, it is important to note that here 4 words, that is concealment, possession, acquisition, or use. These were inserted by amendment of 2012, which was made effective with effect from 2013, February 2013. And
सर बोलो.
Yeah. No, it's not legible now. No, but that pictures I want to see. No, I want to see. Why it is not required? Make it either on top or in no, down. Yeah. So you see, section 3, definition of section 3 is that whosoever directly or indirectly attempt to indulge. Attempt is one part, then knowingly assist is another ingredient, then knowingly is a party is third ingredient, and fourth is actually involved. In what? In any process or activity connected with proceeds of crime. You see, proceeds of crime is an important expression here, which we'll discuss later on. But that includes concealment, possession, acquisition, or use. These 4 words were incorporated in this section by way of amendment in 2012, which was made effective from 15th of Feb 2013. And thereafter, what is more important is that there has to be projection or person, the offender, the money launderer should claim that whatever he has derived, that is untainted. And then, if he claim it as untainted, but it is found to be tainted, then of course, then he is held guilty for an offense of money laundering. Now, in this definition of section 3, an explanation has been incorporated. That explanation was incorporated by the Finance Act. No, I just want this one. Yeah. This explanation was incorporated, by the Finance Act 2019, and the purpose of inserting this explanation was for the removal of doubts. But if we see that what doubt has been removed, the doubt has been removed with regard to concealment, possession, acquisition, or use, the 4 terms which were incorporated in 2013. What doubt has been removed? If we see, if we give combined reading to section 3 with explanation, there is no material change. An attempt has been made to make the offense of money laundering as independent, offense. And it has, that it is not, it will not depend upon the commission of a schedule offense. That attempt has been made. And that attempt has been made in theory, but in practice, because the key word which has been used in section 3 is the criminal activity relating to a schedule offense. So that has not been altered. If that has not been altered, then for the purpose of elaboration and removal of doubt, if you are relating that criminal activity to concealment or possession or acquisition or use or projecting it as untainted or claiming it as untainted, that would hardly, alter the meaning assigned to it in section 3. So this explanation has been inserted by the Finance Act 2019, and like if we see the keywords which were used in section 3, the keywords were proceeds of crime. Ultimately, it is, initially there was a debate whether we should call this act as the Prevention of Money Laundering Act, or we should call this as the Proceeds of Crime Act. If we see the statutory mechanism, if you see the statutory scheme of this act, if we call it the Proceeds of Crime Act, it is as good as PMLA. Ultimately, everything depends upon the proceeds which have been derived from the crime listed in the schedule, which are termed as schedule offenses. So how the proceeds of crime is defined? Proceed of crime is defined under section 2(1)(u), and which means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense or the value of any such property, or where such property is taken or held within the country or abroad. So friends, this is important to understand the concept of POC, which is proceeds of crime. Here, proceeds of crime can be derived either directly or indirectly. So, and they can be derived or obtained by any person. Person is defined under section 2(1)(s). Person are of two kinds. One, legal person, which are also called juristic persons, invisible persons, those who cannot be touched or seen, like firms, companies, association of individuals, body of individuals, and the other category of persons are human beings like you and me, who can be seen and who are visible. So any property, any POC which is derived or obtained directly or indirectly by any person, whether by a human being or by a firm or by a company or by an association of individuals or by a partnership firm, whatever, then if the proceeds are derived as a result of criminal activity relating to a scheduled offense. This is the underlying idea. There has to be a criminal activity. That criminal activity has to be related to a scheduled offense. What is a scheduled offense? We will come to know. Scheduled offense, scheduled offenses are listed in the schedule appended to the act at the end. You know, this act contains 75 sections and a schedule. So schedule is an integral part of the act. 75 sections, then immediately thereafter there is a schedule. And in the schedule there are 29 paragraphs. 29 paragraphs means in total there are 159 scheduled offenses, right? So, what is POC? POC means that any property, whether property is also defined, property may be corporeal, incorporeal, it may be, any property, it may be in cash, it may be movable, immovable, tangible, intangible, whatever is the nature of the property, if it is derived or obtained directly or indirectly by any person as a result, the litmus test is that there has to be a criminal activity relating to a scheduled offense. If in absence of a criminal activity relating to a scheduled offense, you can't even imagine of driving the POC. So the condition precedent is there has to be a criminal activity, and that criminal activity has to be linked to a scheduled offense. So that is the definition. So friends, again, it is important here that by the Finance Act 2019, an explanation has been added, and in that is for the purpose of for removal of doubts. And for the removal of doubt, it is clarified that POC include property not only derived or obtained from the scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense. Now you see the departure. And here again, this has been inserted by the Finance Act 2019, and with effect, it has been made effective with effect from 1st August 2019. But here, the scope of the definition has been enlarged, and it has been expanded. That POC include not only the property derived from scheduled offense, but also any property which is relatable to the scheduled offense. So, here, if it can be related to a scheduled offense, still it will be POC. So the idea is that to make the offense of money laundering as independent offense, which cannot be linked to a scheduled offense, that attempt has been made by inserting this explanation. But the net effect is that ultimately here also you are relating it to the scheduled offense, which means nothing short of scheduled offense would suffice. So now we'll come to know what is a scheduled offense. schedule offense is defined under section 21Y. Schedule offense means three parts of the schedule. Part A of the schedule, part B of the schedule, part C of the schedule. You know, earlier part A and part B is now merged together, and that is part A of the schedule. And part B of the schedule now is on in section 132 of the Custom Act 1962. That is false declaration. The only one schedule offense. And part C of the schedule is section 51 of the Black Money Act. So there are three parts of the schedule: part A of the schedule, part B of the schedule, part C of the schedule. And whatever offenses are specified therein, how many schedule offenses are specified? In all, there are 159 schedule offenses which are listed under the schedule appended to PMLA, which means POC has to be linked, has to be derived, has to be obtained directly or indirectly as a result of criminal activity relating to these 159 schedule offenses. We can't think of invoking the provisions of PMLA in absence of a schedule offense. Now this is about now we have I mean in this we have analyzed the concept of money laundering in literal sense and the concept of money laundering in legal sense. I mean and when we I mean as it has been defined under PMLA, then we refer to first section 21P. From section 21P there is reference to section 3, and from section 3 there is reference to section 21U, and from section 21U there is reference to section 21Y, and the combined reading of these subsections of section 2 will lead to the conclusion that an offense of money laundering has been committed. Friends, there is in the entire act, I explained there are 75 sections and a schedule, and there is a solitary offense, and which is offense of money laundering, and that is section 3. And offense of money laundering is punishable under section 4, and the quantum of punishment is laid down there. That will range between 3 years to 7 years in cases other than I mean cases where proceeds have been derived from those rule offenses. But if the proceeds have been derived from NDPS related offenses, Narcotic Drugs and Psychotropic Substances Act 1985, if the proceeds have been derived from such offenses, then the quantum of punishment will vary between 3 years to 10 years and fine. And in other cases, it is 3 to 7 years and fine. And thereafter, now we'll come to know what are the different stages of money laundering. You know, the International Federation of Accountants classifies money laundering activities into 3 stages. And these are important stages. First is placement, second is layering, and third is integration. Let me elaborate what is placement. Placement is the first stage when the proceeds have been derived from different sources and they are at the command of the money launderer. Ill-gotten money, money derived by illegal means is at the disposal or at the command of the money launderer is the first stage, which is derived from different sources, source A, source B, source C, and source D, etc., which is at the command of the money launderer. That is placement. That is the first stage. Now the money launderer, you know, he is ahead of us. I mean, he is ahead of the lawmakers. He is ahead of the government machinery, the mechanism, and therefore he will devise the ways and means in such a way that the original source, is absolutely diluted, and diluted in such a way that its original source cannot be detected. So in the first stage, we find that money derived directly or indirectly by illegal means or as a result of ill-gotten activities. I mean, this is ill-gotten money as a result of criminal activities, and this is at his disposal. Now he will start gradually. He will keep distance from this money. He will switch over from the stage 1 to stage 2. That is layering, and he will create different layers. Like, say for instance, a money launderer. He earned, let us say, 100 crores from 10 different sources, and this 100 crores is at his disposal. Now he will invest this 100 crores in different, like he will purchase some shares. He will create different layers. He may purchase, he may purchase immobile properties. He may purchase a helicopter. He may build a hotel. I mean, he will create different layers, and he will try to project that whatever money he then invests there, and whatever income he drives there, from there, that would be reflected in the income tax returns, and that will be projected as lawfully earned and legally acquired. So that is the stage of layering, wherein whereby the different layers are created in such a way so that the first source of placement is diluted, but it is not fully diluted. In the third stage, it is fully diluted. What is the third stage? Third stage is integration. Integration is the stage when the money derived from different layers, different sources, is projected as untainted, though its original source is tainted. Then whatever money is derived, that is subsequently projected as untainted, as lawfully acquired and legally acquired. And that is, integrated in such a way that its original source, which is placement, is absolutely diluted. And these are therefore the 3 stages of money laundering. Now, with this background in mind, we'll see, what are the different tools of investigation. You see, this law of money laundering is being enforced by the law enforcement agency, which is the Enforcement Directorate. So Enforcement Directorate is the only law enforcement agency in India which is enforcing the provisions of PMLA. And how they conduct the investigation, what are the different tools of investigation, we will discuss. There are different sections whereby they are empowered to conduct investigation. And we start with the definition of investigation, which is section 2(1) NA. Investigation, the term investigation is defined under section 2(1) NA, which means the purpose of investigation is collection of evidence. Collection of evidence to book the offender. As we discussed I discussed at the outset that the purpose of this law is twofold. One, prosecute the offender, and second, deprive him from the property he has derived or obtained from the POC. So then that will be, that would be achieved only through investigation. And the investigation means the collection of evidence. And what are the different powers of investigation? We deal with these powers of investigation or the tools of investigation, which are like, first is survey, section 16. See, survey is not a search. Survey is lesser than a search. Survey means that the surveying authority, the level of the authority is defined. Level of authority is minimum level is that an officer not below the rank of an assistant director can conduct a survey. So an officer below the rank of the assistant director cannot conduct survey. And there is a purpose behind this, that under section 50 of PMLA, statements are recorded by officers of ED. And there also the level is defined, and the minimum level of an officer who will record a statement is that of an assistant director. So for that purpose, here also, survey cannot be conducted by an officer who is below the rank of an assistant director, for obvious reasons. that when the survey team goes to the site where the money laundering activity is carrying on or has been carried out or is being carried out, the officer may record the statement of the person available at the site. And there, the officer who will record the statement has to be of the rank of an assistant director. So for this reason, the survey cannot be conducted by an officer who is below the rank of an assistant director. Others may assist him, like the other, maybe the members of the team, but the person who will lead the team will be an officer not below the rank of an assistant director. During survey, what is important, like during survey, statement can be recorded. During survey, photocopies of the documents or the statements or the, photocopies of the record, can be obtained. And surveying authority can also affix the seal on the almiras or wherein, the documents of incriminating nature are available, which are suspected to be involved in money laundering. So survey is not a search. Search warrant is not required for conducting a survey. But in exceptional cases, survey can also be converted into search, which is an exception. General rule is survey is not a search. But to every general rule, there is an exception. And what is that exception? That survey can also be converted into search if the situation so demands. For instance, say at the site, the person, he has kept certain documents on his body, on his person, and he has concealed those documents, say currency, foreign currency, etc., and the documents of incriminating nature on his body, on his person. Now, the surveying authority cannot touch, because that is the general rule. They cannot even take out the documents from his body. He has concealed the documents, let us say, under his shirt or, on the pant or trouser, and which cannot be recovered, which cannot be taken, or, So therefore, in such circumstances, because law takes care of such situations, so if in that event, survey can be converted into search, because for search there is a condition precedent that to issue a search warrant, the person below the rank of joint director cannot issue the search warrant. The officer who will issue the search warrant will be not below the rank of deputy director. Now they are termed as, they have been redesignated as joint directors. So to search warrant or the authorization to conduct search has to be issued by an officer not below the rank of deputy director. But assistant director, if he keeps on waiting for, for obtaining the search warrant in a situation which I just explained, then the purpose of law would be defeated. So in such situation, sir, he is empowered by law that the survey can be converted into search, because the exception can be invoked. Now, thereafter, so survey is the first tool of investigation. Second is search and seizure. Searches are of two kinds, basically. One, personal searches, that is search of person, which is defined under section 18. And other than personal searches, rest are covered under section 17. That is all other searches, other than the personal search. All the rest of the searches are covered under section 17. So search of a building, search of a vessel, search of an aircraft, search of office premises, search of residential premises, search of any place, vehicle, etc., can be conducted under section in exercise of the power conferred under section 17. And here there are certain precautions to be taken. One, here search warrant is a condition precedent. Search warrant has to be issued by an officer not below the rank of deputy director. That is one. Second, the person who will lead the team to the site, the team has to be, headed by an officer not below the rank of an assistant director, because here assistant director, he can go to the place, the premises, and show the search warrant or the authorization that look here to the owner or the occupier of the building or the vessel or the aircraft, as the case may be, and explain to him that look here, I have been authorized by my superior to conduct the search of the place, and then there will be complete details of the place where the search is to be conducted. And then that would be shown to the occupier of the building, the owner of the building, the occupant of the building. Or say if the search of a building is carried out, then the person can ask him to show the authority. The authority will be the search warrant or the authorization. And then those officers who go there, their personal search is to be conducted. I mean, they offer their personal search that, look, we have come to search your premises, but we also offer our personal search, and you can search, if you feel that because we are not going to plant any document or anything here, therefore, they offer their search. And thereafter, after search is conducted, during course of search, interrogation, a person can be interrogated, his statement can be recorded, and on conclusion of search, Panchnama or the seizure memo is drawn, because the purpose of search is that where there is search, there is seizure. There can be nil seizure also sometime, but that is very rare. Otherwise, where there is search, there is seizure. So search and seizure go hand in hand, they go simultaneously. So on conclusion of the search, Panchnama is drawn, and that Panchnama is to be witnessed by the two witnesses of the locality. Here it is important to note, and particularly to my friends, the CAs and the advocates, I would, and particularly for defense counsels, it is necessary to note, what happens most of the time, law enforcement agencies, staff of the law enforcement agencies, they carry the witnesses along with them, which is not in accordance with law. What law requires that the witnesses have to be the two independent witnesses of the locality. And if they are not two independent witnesses, then the Panchnama which is drawn, that is not to be accepted, and that is not admissible. So here, on conclusion of the search, the documents which have been recovered from the place or the vessel or the aircraft or the building, those have to be narrated. The detail has to be given, and then the Panchnama is drawn, and a copy of Panchnama is given to the occupier of the building. That is search and seizure under section 17. Then comes personal search. Same procedure is followed in case of personal search. Then in between there is one provision, that is section 17(1)(a). 17(1)(a) is freezing, power of freezing. Here, like accounts can be frozen under section 17(1)(a) of PMLA. And by freezing of account, we mean that once the accounts are frozen, then the operation is suspended, and there cannot be withdrawal from that account. There cannot be withdrawal and deposits, because that becomes that is during investigation. Then that can be frozen, and till it is defrozen, that account cannot be operated. So that is a new provision, 17(1)(a). So after 16, 17, 17(1)(a) and 18, then we come to another tool of investigation, which is power to arrest, section 19. If a person is about to flee the country, if he is about to run away from, or if he is not cooperating with the investigation, or he doesn't want to comply with the with the summons, or he doesn't cooperate, then the person can be arrested. The purpose of arrest is, it is also, one of the tools of investigation. And for the purpose to facilitate investigation, to take the investigation to logical end, this power can be exercised, and that power is given under section 19. And here also there is again an officer not below the rank of an assistant director, will exercise this power. You see, if we see the hierarchy of ED officers, it starts from AEO, that is Assistant Enforcement Officer, then Enforcement Officer, then Assistant Director, Deputy Director, Joint Director, Additional Director, Special Director, and Director. So the power of arrest, it can be exercised by an officer not below the rank of an Assistant Director. AEO, Assistant Enforcement Officer, an enforcement officer cannot exercise this power for the simple reason that you are dealing with somebody's personal liberty. When you arrest a person, his liberty is curtailed, and right to personal liberty and life and personal liberty is guaranteed under Article 21 of the Constitution of India, which means that no person can be deprived of his life and personal liberty except in accordance with the procedure established by law. And that procedure has to be just, fair, and reasonable. If the procedure is unjust, unfair, and unreasonable, then you cannot even, there will be violation, there will be a violation of fundamental rights guaranteed under Article 21 of the Constitution of India. For this reason, care has been taken under Section 19 that arresting officer has to be an officer not below the rank of an assistant director. That is one. And secondly, he has to apply his mind on the basis of material available before him that the person he is going to arrest is guilty of an offense of money laundering. Which means that if a person is not guilty of an offense of money laundering, you can't arrest him just for sake of fun. Just for, to satisfy your ego. If a person is running away, is about to flee the country, or he is not cooperating with the investigation, or if he is guilty of offense of money laundering, of course he can be arrested. His liberty can be curtailed. But you have to come to a reasoning, a finding that on the basis of material placed before me, I am satisfied that so and so is guilty of offense of money laundering. So thereafter, I told you that this is an important, section 50, whereby summoning power is given to the ED officers. This summoning power is for two purposes. For basic purposes, for production of documents and to give evidence. A person can be issued summon by the summoning officer, and here also the officer who will issue the summons has to be of the rank of an assistant director, deputy director, joint director, this additional director, special director, and director of enforcement. They are empowered to issue summons under section 50 of PMLA, and the purpose of issuing summon is twofold. One, for the production of document, and secondly, they may be called upon to give evidence, and here the statement would be recorded. Here, it is pertinent to mention here that most of the investigation of the ED is simply based on this recording of statement, because otherwise there are other tools of investigation, as we have just seen. They should conduct surveys, search, seizures, search of person, but most of the time, they rely upon this. Either they will arrest, exercise the power under section 19, or they will simply record the statement under section 50. Thereafter, they will arrest and produce the person, and thereafter they will seek remand, they will seek enforcement custody, that is EC, enforcement custody. You know, officers of enforcement, friends, just note down, this is an important point which I am going to discuss, that officers of enforcement are not police officers. Whatever statement is recorded by a police officer under section 161 of CRPC, that is hit by section 25 of Indian Evidence Act, and that is inadmissible. That has no relevance in law. That is inadmissible in law. And whatever statement is recorded by an officer of enforcement under section 50 of PMLA, that is admissible. That can be used against the maker of the statement. And therefore, when a statement is recorded by an ED officer, that is an officer of the rank of an assistant director, a caution is administered at the outset, in the beginning. And that caution is, when a person appears on the day and the time, at the appointed time, then a caution is administered that whatever statement you will make, that may be used against you. Therefore, whatever you will depose, that would be a truthful disclosure. That will be your true statement. And that caution is administered in the beginning. And thereafter, question answers, questions would be posed and answers would be given by the maker of the statement. And sometimes they insist that, statement is typed by the steno, by the assisting staff, and questions are dictated, and then answer is given by the maker of the statement. But here, as a precautionary measure, we should insist that the statement should be in his own handwriting. If a person is illiterate, if he is qualified, or even if he is, he understands the regional language, he can like Punjabi, Hindi, whatever language he knows, it is better he should record the statement in the language he knows, and that should be in his own handwriting or in her own handwriting, for the simple reason that then that element of coercion, element of torture, element of force is ruled out. Otherwise, if it is a dictated statement, then that can be challenged, that can be immediately retracted. And if it is, the maker of the statement should insist on it, that I will make my statement in my own handwriting. You've raised the questions, I will answer the questions. And there should not be any dictation. Like whatever questions what the maker feels are, it should be a voluntary statement. Whatever he feels that is a true disclosure, that statement should be made. It should not be a dictated statement. It should not be based on torture, force, coercion, or it should not be by show of authority by the officers of the ED. It has to be a voluntary disclosure. If it is not a voluntary statement, it has to be retracted at the earliest opportunity. Retraction at the earliest opportunity is of legal consequence. But if retraction is not at the earliest opportunity, and if there is a delay or inordinate delay, then it is viewed otherwise, that it is at the advice of the counsel or the advocate. So recording of statement is an important tool of investigation. And here, whatever is recorded, it is as good as it is recorded by a judicial officer, because the statement recorded under section 50 is treated at par with a statement recorded by a judicial officer under section 164 of CRPC. When a judge records a statement, he records his statement under the statement of the accused under section 164 of CRPC. And there also caution is administered to the accused that, look, whatever you depose, whatever you make, whatever you disclose, that can be used against you. So make a true disclosure. Similarly, here also, it is as good as a statement recorded by a judicial officer, and it is admissible. Now, we will, power to summon, production of document and evidence we have discussed. Now here, thereafter, section 56 is there. if some evidence is available or some documents are lying in a foreign state, in a contacting state. Contacting state is a foreign country, is a country outside India. Then the government of India, the central government, is empowered to enter into an agreement with foreign countries, and that provision is there under Section 56. Under Section 56, there are two type of agreements. One is mutual legal assistance agreement. The other is mutual legal assistance treaty, and that is provided under Section 56. And both are like through MLA A, mutual legal assistance agreement, and through MLAT, the evidence can be obtained from a contacting state. Then come letter of request, LR. LR is like a letter of request which is issued by the special court designated under PMLA, and that is issued under Section 57 of PMLA to a court or authority outside India, that is in a contacting state. And whatever is received from a contacting state, that becomes admissible in law. That can be used against the accused. So this was about the tools of investigation. Now let me just when the investigation is taken to logical end, the purpose is either the prosecution complaint will be filed or the property will be attached, or both can go simultaneously. So first we will deal with attachment of property, which is under Section 5, subsection 1 of PMLA. Here, what is the, on completion of investigation, if the investigation lead to the conclusion that the money launderer derived or obtained directly or indirectly some property which is the source of which is tainted, so unlawful, the source of which is ill-gotten, then that property can be attached under Section 5(1). But for attachment, there are two important ingredients. One, that there has to be some material in possession. That material has to be of incriminating nature, and there has to be, the officer, the attaching authority, he has to record reasons in writing, reason to believe that I am satisfied on the basis of material that these properties are involved in money laundering. Therefore, these are being attached. Now, what happens sometimes, in short, we are calling it PAO. PAO means Provisional Attachment Order. The life of PAO is only 180 days. After 180 days, it dies its legal death, unless it is extended, it is confirmed by the adjudicating authority. Adjudicating authority is a quasi-judicial authority other than the enforcement directorate. So here, the attachment power, the power of attachment is given to the ED. Under Section 5(1), attachment order is passed, it is unilateral order. No hearing is afforded. It is an executive order by an officer of the rank of deputy director. Here again, the rider is minimum rank required for passing an order of attachment is that an officer not below the rank of deputy director can pass an order of attachment, which is called PAO. And PAO, now what happens, like say, I give an example here, supposing one has, derived or obtained 100 crores, and that the source of this 100 crore is ill-gotten, unlawfully acquired, illegally acquired, and out of this, this was hard cash, this 100 crore, and that 100 crore he dumps into sea. He has thrown away that 100 crores. So, there is nothing available for attachment. Now, what is to be done in such cases? Then there is a provision that whatever he has derived or obtained lawfully, legally, that can also be attached for equivalent value. If that 100 crore which he has dumped into a sea is not available with him, but other properties are available, and the source of such properties is lawful, and such property can also be attached for equivalent value. And so what is equivalent value? That is important. Section 60 deals with the attachment, seizure, and confiscation of property in a contacting state or India. And the order is passed by the officer of the ED. If the property is lying in a contacting state, then the instructions will go from here that those properties can be sold and its proceeds can be repatriated to our country. So even if the property is outside India, that can also be attached if it is involved in money laundering. So I was explaining what is equivalent value. What is equivalent value? Condition for attachment of property for equivalent value are threefold. One, proceed of crime has been alienated, disposed of in any manner. Where proceeds of crime is not traceable or the authorities fail to trace proceeds of crime, and where the person responsible has received illicit gain of the criminal activity relating to schedule offense. Now here I would like to discuss the three judgments only. In these three judgments, first is what is equivalent value? How the equivalent value has been defined by different high courts. High Court of Delhi in Deputy Director AD versus Axis Bank, which is the latest case of 2019, reported in SEC Online Delhi 7854. Here, the High Court of Delhi held that if the enforcement authority under PMLA has not been able to trace the tainted property which was acquired or obtained by criminal activity relating to the schedule offense for money laundering, it can be legitimately proceed to attach some other property of the accused, provided that it is of value near or equivalent to the proceeds of crime. Like what happens, most of the time it happens that sometime the entire building is attached, which is not proper. It should be nearer value or equivalent value. You can't attach, if it is joint property which cannot be divided, of course that is a different thing. But otherwise attempt should be that the property has to be tainted property, and thereafter you can attach the equivalent value or the equivalent which the value which is near to it. So that is High Court of Delhi in the Axis Bank case. Another judgment is of Punjab and Haryana High Court, which is latest. This is Seema Garg case. Here this was decided on 6th of March 2020, and here it was held by Justice Jaswant Singh. In fact, I was there before the same judge on that day. And then he invited me and discussed this case. In fact, in his chamber, we discussed it for quite a time. And he discussed this concept of money laundering. And finally, this judgment came, and this is a very good judgment, landmark judgment. Here it has been held by the High Court that if the property is acquired prior to commission of schedule offense, that is criminal activity. If the criminal activity is prior to commission of a schedule offense or introduction of PMLA, then that cannot be attached for equivalent value. Unless only those properties which are taken, which is held or taken outside the country can be attached. Otherwise, we cannot attach anything, under the garb of equivalent value. So High Court of Delhi, High Court of Punjab and Haryana High Court Chandigarh, and then a very good judgment by Justice Manmohan Singh, that is the appellate tribunal, in Surinder Singh versus Joint Director, Directorate Enforcement, Hyderabad. It was decided on 21st of December 2018. What is happening these days? The ED is adopting shortcut method. The purpose of investigation is to take the investigation to logical end, and thereafter you attach the property if the property is involved in money laundering. What they are doing most of the time, it is seen that the property, most of the time they just attach the property for equivalent value, because otherwise they should trace the POC, the source. So therefore, in this case, Justice Manmohan Singh rightly held that for the attachment of equivalent value, exercise can only be done if ED is not in a position to recover the actual amount of POC from the accused, who by manipulation spent the POC, and ED is not able to recover the same and attach that only under those circumstances. The property can be attached equivalent to value thereof if the party has some link and nexus in the crime, or the attached property was purchased from the POC. You can't just jump on anybody's property or any property and attach the property. So take the investigation to logical end and see if there is nexus with the POC nexus with the criminal activity relating to schedule offense, only then you attach. Otherwise, under the garb of equivalent value, you can't attach any property, even the property which is lawfully acquired. So these are the three judgments on equivalent value. Now, friends, the life of this PAO is just 180 days. Now the procedure is that under section 5.1 attachment order is passed, which is PAO. Under section 5, subsection 5, complaint is filed before the adjudicating authority, and that complaint is filed by the ED, and the prayer in that complaint is that the attachment order should be confirmed, and that complaint has to be filed within 30 days from the date of attachment before the adjudicating authority. Adjudicating authority is a quasi-judicial authority, and under section 8, there are certain stages which are, or the powers which are invoked by the adjudicating authority. Under section 8, subsection 1, adjudicating authority on the basis of material placed before him has to issue a notice of not less than 30 days to the defendant that you show cause as to why the attachment order should not be confirmed against you. So that is 8.1. Under 8.2, opportunity of hearing is given to both the sides, that is AD and the defendant. Under 8.3, order is passed. Under 8.2 also, order is passed by the adjudicating authority. He has to apply his mind under 8.2 also. But under 8.3, he has to pass a detailed order for confirmation of attachment. Once the order of this time, Oh, doesn't matter. You see, once the order is confirmed under 8.3, thereafter the ED is empowered to take the possession of the attached property forthwith. That is 8.4. And under 8.5, it is the special court which will confiscate the property involved in money laundering. Now, earlier, under 8.5, it was the adjudicating authority which was empowered to, confiscate the property. But now, by way of amendment, the power has been given to the special court designated under Pmla to confiscate the property involved in money laundering. Under 8.6, the property can be released if it is not involved in money laundering. Under 8.7, there could be a case of confiscation or release as the case may be. Under section 8.5, 8.6, 8.7, 8.5, 8.6, the condition is that confiscation will be on conclusion of trial for offense of money laundering. Release of property will also be on conclusion of trial for offense of money laundering. And under 8.7, if the trial could not be concluded for one reason or the other, say for example, the accused has been declared proclaimed offender, or accused has not cooperated with the investigation, or accused has run away from the, he has run away from the court, or he has flown the country, he has gone outside India, then in the trial cannot be concluded for one reason or the other, or or by reason of death, whatever may be the case, then in that event, AD may apply for confiscation and the aggrieved party may apply for release of the property as the case may be. That is 8.7. And 8.8 is restoration of confiscated property. Say if the property is wrongly confiscated, then property can still be, restored to the lawful claimant, to the person who claims it that it is not involved in money laundering. And this 8.8 has been incorporated by amendment. Now, on confirmation, then thereafter on confiscation, after confiscation, the property is vested in the central government under section 9 as if it is free from all encumbrances. And confiscated properties are managed by the officers of the directorate who are of the rank of joint secretaries, and the officers of the rank of joint secretaries are the special directors. So such properties are being managed by the special directors, and they are treated as they are empowered to manage such properties under section 10 of the Act. Now, prosecution. What is prosecution? Let me briefly tell you about prosecution. Purpose of Pmla is twofold. One is deprive the money launderer from the property he obtained directly or indirectly as a result of criminal activity relating to scheduled offense, confiscate such property, and also prosecute him. So prosecution is an important, that is one of the aims of the act. So the prosecution is the trial for this offense of money laundering is conducted by special court. Special court is designated under section 43 subsection 1. It is designated by the central government in consultation with the Chief Justice of the High Court, concerned High Court. And on completion of investigation, prosecution complaint is filed before the special court. You see, like police files challan, police files police report, police files, this challan or police report under section 173 subsection 2 of CRPC. Similarly, on completion of investigation, ED officers files prosecution complaint before the special court. And the special court, the complaint is filed under section 45 of PMLA, second proviso to section 45 of PMLA. Thereafter, the special court shall take cognizance of the offense under section 44B. Under 44, section 44 of PMLA is very important. It is divided into 4 parts. Part A deals with that offense of money laundering and schedule offense shall be tried by the same court. Like say if A has committed an offense of murder, so the trial of murder shall be initiated, shall be conducted by police. And the offense of, by committing an offense of murder, let us say he derived 10 crores. So for the, and which that 10 crore he projected as untainted, and he laundered and projected as untainted. Then for this, which means he has also committed an offense of money laundering. So for this 10 crore, there will be a money laundering trial, and that will also be committed before the same court. So same special court will conduct both the trial. The reason being that, if there is commission of a schedule offense, that trial has to take place before the same court. Otherwise, if the right hand doesn't know what the left hand is doing, then we will, will go astray. We will not reach the destination. So therefore, the power has been given to the same court, and that is special court. And under section 44A, that power is given, that the same court shall try both the trials. And 44B, that on the prosecution complaint, once filed by the ED, cognizance of offense of money laundering shall be taken by the special court, whether the offense of money laundering under section 3 has been committed or not. That is under section 44B. Then 44C is money laundering trial shall commence from the stage it was committed. Say for instance, the police trial is going in a different court. Then the money laundering, say for instance, the money laundering, the police trial is going in a Saket court, and the money laundering trial is in Patiala House Court. Then the application shall be moved by the ED officer before the Saket court, that this trial has to be transferred to the Patiala House Court, which is designated under PMLA, and both the trials shall be conducted before the same court. So by virtue of section 44C, that both the money laundering trial shall commence from the stage it was committed. And the same, the other trial, which has been like Saket trial, shall also commence from the stage it was transferred to the Patiala House Court. That is the purpose of this 44C. Then 44D is that the provisions of CRPC shall apply. PMLA is a special law, and whatever provisions are laid down in the special law, those have to be followed. Because, but under section 65 of PMLA, there is a saving clause, and that if the provisions of the CRPC are not inconsistent with the provisions of PMLA, then the provisions of CRPC shall also apply. So by virtue of that, section 44D is there, which means that provisions of CRPC shall apply to money laundering trial also, right? And what these sections are section 225 to 237 of CRPC, because money laundering trial is a session trial. And for session trial, the relevant provisions under CRPC are section 225 to 237 of CRPC. Section 45 says that offense of money laundering is cognizable and non-bailable. And this I have already discussed, that prosecution complaint has to be filed under second proviso. Under section 45, twin conditions are there. If one applies for bail before for an offense of money laundering, then there are two twin conditions under section 45, subsection 1. One is the court is satisfied that he is not guilty of offense. That is one, and he is not likely to commit any offense while on bail. If the two conditions are satisfied, then only the bail can be granted. These twin conditions have been declared unconstitutional by the Supreme Court in Nikesh Tarachand case. Nikesh Tarachand versus Union of India, reported in 2018-11 SCC, page 1. And there, the Supreme Court has taken a view that both the twin conditions are unconstitutional. Now, therefore, earlier, jail was the rule and bail an exception, but now bail is the rule and jail is an exception. Because the twin conditions were very stringent conditions, and the court was really, no court will take a view that the person is guilty. A person will not commit an offense of money laundering while on bail. No judge can anticipate and apprehend that. Similarly, the court has to satisfy that he is guilty of offense of money laundering. At the stage of bail, it is premature to say that he is guilty of offense of money laundering. So on conclusion of trial, court can take that view. But at the stage of, at the bail stage, it is difficult. That's why Supreme Court has declared these twin conditions as unconstitutional. So thereafter, what are the recent trends? One is trade-based money laundering. Trade-based money laundering, is a recent trend. Money launderers have devised this mean of, trade-based money laundering. This is not very rampant in our country, but it is very common in foreign countries. And here, according to International Narcotics Control Strategy report, hundreds of billions of dollars are laundered annually by way of trade-based money laundering. It is one of the most sophisticated method of cleaning dirty money, and trade-based money laundering red flags are among the hardest to detect. Trade-based money laundering is the process by which criminals use a legitimate trade to disguise their criminal proceeds from whatever proceeds are genuine, those are disguised by the, whatever are the sophisticated one or the fictitious one, those are projected through this trade-based money laundering. And this is very common in foreign countries. Now, this another recent trend is cryptocurrency. Cryptocurrency is also known as virtual currency, digital currency, bitcoins. This is also a term which is, which is known to foreign jurisdictions and contacting states. Cryptocurrency is a digital asset designed to work as a medium of exchange to secure financial transactions. It is not physical currency. It is not currency which is available in hand. It is something, which is just mere hypothesis, like digital currency, virtual currency, or bitcoins. So some countries have positive approach towards the concept of digital currency. But India is a developing country with a continuously growing economy, and therefore the concept of cryptocurrency is quite new to India. In the Union budget for 2018-19, and the RBI did not recognize this Bitcoin as legal tender. And here I can remind you that the RBI issued a circular on 6th of April 2018. And through that circular, this Bitcoin, digital currency, cryptocurrency was banned. So that circular of 6th of April 2018, which banned the digital currency or the Bitcoin or the cryptocurrency, the virtual currency, that was challenged before the Supreme. It ultimately went to the Supreme Court, and the Supreme Court, in the case of Internet and Mobile Association of India versus Reserve Bank of India, which is reported in 2020 SEC Online, Supreme Court 275, it has lifted the ban on cryptocurrency transactions. And the circular which I just quoted, that circular issued by the RBI, circular dated 6th of April 2018, issued by the Reserve Bank of India, banning these cryptocurrencies, digital currencies, and bitcoins, that has been declared. That has been declared. That has been set aside, and now it is accepted as a legal tender. Now, friends, look here. Any law declared by the Supreme Court is binding. That is law of the land by virtue of Article 141 of the Constitution of India. But it is a mixed bag of risk and rewards, being double-edged sword till the guidelines are framed by the central government in consultation with the RBI. So law has to be enacted on this, and the guidelines have to be framed and outlined as to how this cryptocurrency and bitcoins or virtual currency would be a legal tender. So it is yet to see the light of the day. So, and the another thing which I must point out here is that this is not a part of the schedule. So it is not a schedule offense. If it is not a schedule offense, it cannot be related to offense of money laundering. Thank you. Now I invite questions from the audience.
Okay, sir. Okay.
Rajesh ji, can I come in? Amit Khemkar is sir.
Okay, sir.
Rajesh ji.
Sir, please go ahead.
Yeah. Dr. Saab, it was a very lucid and excellent presentation by you, and who can be better than you, who has played a role in drafting of this law and the formation of this law, and who has such a vast experience. So I feel, I think all of us have been enriched by the immense knowledge which you have, although we have only got a fraction of it, and we will keep on learning it from you. However, I have one or two small queries. One of the queries, Dr. Saab, is that the definition, the addition of the explanation in section 3 of the definition of money laundering, whereby there is an effort, if you read, if one reads it, there is an effort to say that one has to read that conjunctive and as or. So how does one actually harmonize the main definition and also the explanation? So that is my first question, Dr. Saab. And the second question is, section 44, when the new amendment to 44 says that any order passed by the court dealing with the scheduled offense will have nothing to do with will have no bearing on the trial of the PMLA offense. Now, as we understand that the whole basis of PMLA, whole basis of the offense of money laundering is the happening of or committing a offense which is scheduled offense. Now, does it mean that if a person has been acquitted for the scheduled offense, still the offense trial of money laundering can go on? Will this proviso which has been added now? So these are my two small, which is troubling everybody. So I thought that who better than Dr. SHAMSUDDIN to just do this brainstorming.
Thank you very much, Amit Khemkar ji. In fact, due to paucity of time, I could not elaborate the topic I was assigned because it is time consuming. But that's why I just summarized it. Very pertinent questions you have raised. First question relating to addition of explanation in section 3. If we just carefully peruse the definition of section 3, there the entire section is, in entire section, the definition of money laundering, one conjunctive is used, and that is and, which means that, subsequently in explanation, disjunctives have been used, and particularly in the 4 words, with concealment, possession, acquisition, or use. Concealment or possession or acquisition or use, relatable to schedule offense. But if we give the combined reading of the section with the explanation, then we lead to the conclusion that the key expression is criminal activity relating to a schedule offense, and that has not been taken away, even in explanation. So,
No.
can
I come in, sir? Can I come in, sir?
Yes.
Sir, earlier the definition as we understood was that projection or claiming as untainted property was the most important requirement for the offense of money laundering to happen.
Yeah.
Now, even for projecting or claiming, the word or has been utilized.
Yeah. No, but yes. In the amendment of 2012, these 4 words were used, that any person who directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected with proceeds of crime, including concealment, possession, acquisition, or use. And then so these 4 important words were inserted by amendment in 2012, which was made effective from 15th of Feb 2013. Then thereafter, there was no necessity of incorporating or inserting this explanation at all, because in the explanation an attempt has been made that these 4 words, have been, against the 4 words, disjunctives have been used: concealment or possession or acquisition or use, and relating to a criminal activity which is not relatable. Here in the explanation they have used the term relatable. So this is if we give combined reading of the explanation with the definition, then we can't make it stand-alone offense. Offense of money laundering is not a stand-alone offense. This is my personal view.
No, I agree with you.
For commission of an offense of money laundering, there has to be commission of a schedule offense, and the POC should be derived from such schedule offense. In fact, in my book on commentary on PMLA, I don't know whether you have gone through, I have revised that book. You will see that revised edition very shortly in the market. In fact, in my book, I have quoted that 2G scam, that order of special court, and in 2G scam, 2G spectrum case, first there was acquittal in CBI case, and on that basis there was discharge of the accused from the offense of money laundering in money laundering trial, which is quite relevant. And that judgment of the special court has been challenged before Delhi High Court, but there is no stay against that order. But though there is some restraint against the properties, but as far as the accused persons are concerned, there's no adverse order on that. So my answer to first question is that if we take a harmonious view of the explanation, section 3 as a whole in totality, then ultimately, in my view, offense of money laundering has to depend on the commission of a schedule offense. And it can never be a standalone offense in the statutory mechanism of this act. If you make it a standalone offense, then you have to do away with the schedule. You can't go with the schedule as well as make it an offense of money laundering independent of schedule offenses. That is answer to question 1. Then answer to question, that is very important, section 44. You see, I think I have answered that also, that if you if the proceeds have been derived from the schedule offense, then it is those proceeds which have to be dealt with in the offense of money laundering trial. I know that whatever is derived from the schedule offense, it is that POC which is subsequently laundered and projected or claimed as untainted. So you can't just segregate the two. Again here also, by inserting explanation, the meaning is not altered. So in both the cases, the offense of money laundering depends upon the commission of a schedule offense and driving or obtaining the POC from such schedule offenses. And in total, there are 159 schedule offenses. So we are concerned with those 159 schedule offenses alone and not, with other offenses. So whatever is derived from such schedule offenses which are listed in the schedule have to be projected or claimed as untainted. And if in that event, the offense of money laundering will come into play only when the schedule offense has taken place. To elaborate further, I give just an example. Say, for instance, A killed somebody on 1st of June 2015 in CP, not place New Delhi, on 1st of June. And he extorted, let's say, 5 crores before killing him. And that 5 crore is subsequently projected by him as lawfully acquired and invested in different, purchase of shares, properties, etc. And subsequently projected as untainted property. Now, in trial, when the trial of murder takes place, the defense of alibi is taken by the accused. That on 1st June 2015, he was undergoing a surgery in London. So the question of committing an offense of murder in daylight, and that too on 1st June in Delhi, that is absolutely ruled out. And that is highly improbable. In that event, then he is acquitted. Now, if he is acquitted for the schedule offense, now the AD people, they say, no, this money, this 5 crore is projected as, it is independent offense of money laundering, and he will be punished for that. But they are interlinked. If he has not committed an offense of murder, how he can, the question of driving that 5 crore from that offense of murder, which is a schedule offense, that doesn't arise. So therefore, both go hand in hand, and both can't be segregated from each other.
Well, only the confusion has been increased,
Yeah.
Work for lawyers and courts has been increased.
Yeah. So good question, Kamkaji, very good questions. Thank you.
राजेश जी, आपकी आवाज आ नहीं रही है.
दमीजा जी, ask your question.
वॉइस थोड़ी सी और बढ़ाएं राजेश सर. वॉइस.
दमीजा जी, ask your question. दमीजा जी.
दमीजा सर.
सुनील दमीजा जी से कह रहे हैं राजेश जी क्वेश्चन पूछ लें.
ने हैंड रेज किया हुआ है.
Yeah.
My question, times frame he played. I started to when I committed an offense or any such, let's say 20 years before, can he still be tried that?
Voice is not clear. It's not audible. Voice is not clear. I can't.
Voice is breaking. Voice is breaking.
Yeah, the voice is breaking.
Sir, if you can read, if any there is a question in
How is now, sir? Hello.
जी सर. हेलो.
सर चैट पे क्वेश्चन है.
धमीजा जी, अगर चैट पे लिख दें, आपकी आवाज नहीं आ रही, चैट पे लिख दें तो somebody else will read and ask your question.
अभी सुनाई दे रहा है? When am I able to say?
नहीं सर, आपकी आवाज नहीं आ रही.
Okay. चलिए, कोई बात.
I have one question.
हाँ सर, पूछिए सर.
जी सर. Yes sir, doctor sir.
Yeah, fine. Thank you.
Yes
Thank
sir.
you.
Yes sir. So मेरा question है related to the definition में एक word दिया गया था knowingly.
Yeah.
So being a practicing chartered accountant, I am working as an auditor. So we are auditing so many, the audit from of the private limited company. So during, the while auditing the books of account of the company, हमने जितने भी institute के guidelines हैं, जो भी circulars हैं, जो भी, institute की तरफ से practical guidance आती हैं, we have applied all the guidelines.
Yeah.
But due to कह सकते हैं कि lack of like the information of the supporting evidence, we cannot find out जो उसमें money launder हुआ है.
Yeah.
But after 2 years from the audit date, we got a letter from the ED. Okay, yes, there was a money launder and you were the auditor. So आपने उस चीज को properly audit नहीं किया, आप तो उसमें knowingly involved थे. So how we can, the differentiate this word knowingly and unknowingly in that case?
See,
it's very difficult.
If there is no mens rea, I mean that the offense of money laundering cannot be attributed to CAs. If the CA is performing his duty in accordance with his best ability and efficiency and as per laid down, standing these norms and guidelines, then in that event they can't. I mean, this is misuse of power. If they just issue a letter to a CA and or someone to a CA and saying that you have done it knowingly, because knowingly, I mean that puts onus on them. They have to discharge that onus. If they say that you have done it knowingly, what is the evidence? See, there our answer should be as a CA that you should be law abiding. That's all. That you have taken into consideration all the guidelines, all the norms and the standards, laid down norms and standards, and you have audited under a bona fide belief while taking all precautions and guidelines into consideration. So then there is nothing to worry and apprehend.
But it's very difficult.
I'll like to add something there.
Yeah.
The trials which where we are seeing every day, that almost, because all these matters are related with finances, and the fiscal matters, and at some stage or the other, some company secretary, some chartered accountant, they are always involved in those transactions in one way or the other, remotely, directly, indirectly. So almost in every case which we get, there are chartered accountants or company secretaries who are co-accused in these cases. So the fact remains that the time has probably come for even the chartered accountant community and even for the institute to add certain more guidelines and to look for even these kind of suspected transactions which seem to be unanswered. I mean, where any kind of benami transaction or criminal activity or something like that is suspicious. There also it has become necessary today, I think, for the chartered accountants to be guided, and that is why probably you people are making Rajesh ji, people like Rajesh ji and others are making so much of efforts so that you people understand the concept at least, and it is always on the back of your mind that there is a law called Benami PBPT Act, there is a law called PMLA. So all these laws should be at least on the back of your mind while you are performing your duty.
Very right. Very
and that is required. You need not be the experts, or you need not be the you need not go deeper into these things. However, you must understand the definition at least. That is why I troubled Dr. Saab with the definition part only, which has been made more confusing today. But you have to be careful about both the definitions. I mean, both the interpretations. So I think if one is a little bit careful, and if the approach is arm's length approach, then a professional can always keep himself safe. The problem with chartered accountants is that most of their clients become their family members over the years. You know, you are working for a client for 40 years, 30 years. हमारे साथ में प्रॉब्लम ये है, client आया, एक केस किया, घर गया. So they don't become our family members. But
Right.
you know, in your case, they become your family members. So at times, chartered accountants start identifying themselves with the client, and that should be avoided at all costs. You must work with totally, arm's length approach. That is what is the order of the day. That is what is the requirement of the day today.
So I agree with Khemkaji. In fact, Institute should organize more and more courses on this Benami and this PMLA, and so that our CAs and company secretaries, they understand the gravity of the subject. And if they know more and more about less and less, perhaps they will not commit these mistakes, while auditing and that is required. So that is required. And Rajesh, I would suggest that you should organize more and more courses on these subjects, because these are the new areas, new subjects to the CAs and CS, company secretaries.
Moreover, sir, today CAs are the best scapegoat for all authorities concerned. So it is better to call CA, issue letter to a CA, and everything can be done. So this is also playing a major role from authorities against the lobby.
Goyalji, as आपको, I'll just when I was there at your study circle, I had shown the connection between the income tax law, income tax violations, and PMLA.
Yeah.
I'll just explain it in a very small thing. For any kind of tax evasion, as such, income tax offenses are not in the scheduled offense. But for committing any kind of tax violation, a person would have forged bills, fabricated bills, or some kind of a document which can come in the definition of forgery.
Yeah.
And forgery is one of the scheduled offenses.
Yes.
Okay. Now, that means that that person can be prosecuted for forgery, and the income escaped by him or income earned by him in a way will be subject matter of prevention of money laundering. So that way, if you see that even to that extent, one has to be careful now.
Yeah.
Earlier, the income tax department was not prosecuting the people for income tax violations. Now they have started launching the prosecutions, but still they are not adding the offense of forgery. But tomorrow, when they start adding the offense of forgery, then it will also start falling in the PMLA.
Yes.
Here I would Khemkaji has explained this nicely, but to add it further, under section 3, the term knowingly, whosoever attempts to indulge or knowingly assist or knowingly is a party or is actually involved. So actually is also knowingly. So if the role of the CA or the CS is that he is actually involved, or he knowingly assists, or he is knowingly a party to the financial transactions which are involved in money laundering, then in that event he is liable. He comes within the definition of section 3. But if he is performing his duties, in good faith, taking all precautions, and he is not involved, he is not even the beneficiary of it. Whatever professional charges he takes, that is something different. That is part of the professional duty. But if he is involved in it, if he is the beneficiary of it, then in that event, the liability is there. Then in that event, so better course would be that the CA has to be, more conversant with the provisions of PMLA, a more, familiar as he is familiar with the provisions of ITA. Similarly, he has to become conversant with the provisions of this PMLA. Then, if you know the subject well, then you can answer it. You can answer the questions raised by the AD officers accordingly, and particularly you can show your that your intent is you know I mean there is no malice, no mens rea, and that you can explain.
And to add to what Amit Khemka ji has said, at times, sir, whatever forced documents are there, they are so forced, planned way, you cannot pick and have a suspect on that. Normal transaction may have some lacunas, may have some finding that this is missing, wherein the forced documents, everything will be perfectly fine. Because they've made with plan.
No, as Dr. Saab explained, that till they are not actual or knowingly, till then you are safe. That is why I use the term arm's length approach.
Yes.
जहाँ पे क्लाइंट के पास ये स्कोप है कहने का कि मेरे को तो सीए साहब ने सजेस्ट किया था, मेरे को तो सीए साहब ने बताया था, मेरे को तो उन्होंने अरेंज करवाया था. As soon as that happens, the trouble starts.
Then you are in trouble.
The trouble starts. So till you are working as a professional purely, and till you are working as with the arm's length approach, dispassionately, till then you are safe, and at least even if somebody wrongly implicates, then courts and we lawyers will come to the rescue. But once it is, if a chartered accountant is actually involved, then what do you do?
Yeah, there is no escape then. There is no escape.
Thanks, sir. Thanks for elaborating.
And thank you over to Rajiv Kohli ji for a vote of thanks, sir. Kohli Saab.
Thank you, Dr. Saab. Such an eminent personality, deliberating in such a judicious, comprehensive, lucid manner on the nonsense, all the intricacies, right from the international background since 1998 till 1999, the second bill, then how the things evolved in India, what the IFAC does, what the multilateral agreements are, the treaties are for attachment of properties, and all the judgments. Because basically there is no end for greed, and wherever you are obtaining any pecuniary benefit from the proceeds of crime, so that is being hit by this section, so all these deliberations. So as very rightly mentioned by Advocate Khemka ji, the arm's length has to be taken place. Because unfortunately, if CAs and doctors become family relationships, it may start from continuously providing the same service or same set of clients. So we have to maintain that, and there should be totally a very simple thing, because end of the day, because audit is normal, but forensic audit, the entire thrust area gets changed. But nevertheless, we have to keep these things, what are developments are taking place, and the white collar crimes will keep on increasing, and we'll have to look at things, what things are happening, and please the government, the more control is taking place. Then there's a thank you very much for the nice deliberation, food for thought-provoking process, because the thought process sets around daily, because a very common thing to have a notice from the ED why you should explain this transaction to us.